Hello everyone, welcome back to my channel UPSC Sathi. Today we are going to discuss a couple of articles which are very important from the both mains and prelims perspective. But before starting, let us first read a thought. If rule of law is absent, then there is no accountability. Then there is abuse of power and corruption. And we are ruled not by the laws, by idiosyncrasies and whims of those in the power. So, can you tell me where we can use this thought? Yes, you guessed it correct. We can use it in the polity and GS paper 4, where we talk about that not only the law, but we also need the ethics of the people who follow those law for the effective implementation of the law. And this particular quote is said by Supreme Court in the context of the Bulldozer Justice that we will see today. So let us start with our first article, that is on the tax burden on the middle class reduced. So this is important from the GS paper 3 perspective economics, and it is talking about that the tax burden on the middle class has reduced with the budget 2024, which raised the exemption limit of the tax from 2 lakh to 7 lakh, and now this has led to the rise in the zero IT return filers. So there is a notable decline in the percentage of the income tax collection from the taxpayer which are earning less than 10 lakh. So this was, and the contribution of the people who are contributing in the tax who earn less than tax has reduced from 10% in 2014 to just 6.22% in 2022. And but the percentage of those who earn more than 50 lakh have increased, so it is a rise of 391%. Now the important takeaway from this observation is that we are seeing that the liability of the tax on the low to middle income earner have decreased, while only those who earn more than 50 lakh have increased around by 391%. Now this shows that, can you guess what type of taxation this shows? Yes, it is progressive taxation. And when we talk about progressive taxation, the thing is important, why it is necessary or why it is essential for an economy, especially an economy like India. We know that we have huge income inequality and wealth distribution. So when there is progressive taxation, it helps us to reduce the inequality, making the growth more inclusive, and it also help in increasing the household savings, because when there is less tax burden, people are able to save more, and when they save more, they are able to the expenditure increases, expenditure on the consumption increases. So when they consume more, what happens when there is more consumption? So they will purchase more. So this will give a boost to the economic growth of the nation. There will be more demand, and when there is more demand, there will be more manufacturing, more employment generation, which will help in the economic growth of the nation. So this is also important from the perspective of pumping up the growth, pumping up the demand in the economy. So progressive taxation is very important to reduce the inequalities and increase the demand in the economy, right? So 76% of the total income tax collection is from the high earners, which is a good sign. Okay, so this was important from understanding why the tax liability has decreased. Now the next is article is on Lancet study, which said that Indians account for quarter of the world diabetes patients. So this is important from the perspective when we talk about the health in GS paper 1 and 2. So we have 1/4 of the world adult diabetes patient, and others are China, USA, Pakistan and Brazil, we can see. And the people who are aged above 30 years, 59% globally are being deprived of the care, and India it is 30%, and this has increased 4 times what it was in 1990. So there are global inequalities because people are not able to get the proper treatment for the diabetes, right? So unhealthy food and all these are contributing to it, and the burden has increased. So now in women it is 13.9%, and in men it is around 14.3%. So this is important from understanding how the burden of non-communicable disease are increasing in India, and we need a holistic healthcare, both in infrastructure, the quality of the healthcare, the detection and all, right? The next article is important because it talks about D-SIBS, that is domestic systematically important bank. Now what are these banks? So this is a very important concept, right? So first let us know what is the news. So RBI has declared and retained SBI, HDFC Bank and ICICI Bank as the D-SIBS. Now who are these banks? So suppose they are the banks which grow very big, right? So there are certain banks which are very big. Why they are big? Because they can be big on the terms of their size, कि उनका साइज बहुत बड़ा है, वो क्रॉस जुरिस्डिक्शनल एक्टिविटीज लाइक दे आर ऑपरेटिंग इन मल्टीपल कंट्रीज, दे हैव कॉम्प्लेक्सिबिलिटी लाइक और सस्टेनेबिलिटी, सब्स्टिट्यूशनेबिलिटी सॉरी, मीन्स दे आर सो बिग, दे आर सो इम्पॉर्टेंट कि कोई और बैंक उनकी प्लेस नहीं ले सकता. एंड इंटरकनेक्टेडनेस means they are very much interconnected. Now these banks are so important for an economy. So what happens that if these banks fail, then it can cause a big shock to the economy. So if they're disrupted, it can disrupt, the failure of these banks can cause significant disruption in the essential financial services that they provide and impacting the overall economy. So it is very important that they work properly to maintain the essential banking services. And now for this, the government support these banks, the government protect so that these banks do not fail, because if they fail they will have more risk. Now when the government is supporting such banks, they also become some laxative, they become they can undertake the risk, they can undertake risk taking loans or reduce the market discipline, creates the competitive distortions and increases the probability of the distress in the future. So to prevent this, certain limitations, some restriction or some policy measures need to be taken so that we can ensure that these banks follow the discipline, they are hedged towards more risk in the future. So government support is there, but also certain policy measures they need to follow. So there are additional policy measures to deal with the systematic risk and moral hazard issues which are posed by them. So such banks are known as domestically systematically important bank, because domestically they operate or they are formed within the borders of the country, and they are very systematically important. They are too big to fail. If they fail, they will cause huge disruption. Now, how these banks are identified? So what RBI has done? RBI has created these 4 buckets. ठीक है, अब ये 4 बकेट में हर एक बैंक्स को डाला जाता है. हाउ, उनकी 2 स्टेप प्रोसेस होते हैं, उसके बेसिस पे इन बैंक्स को डाला जाता है. तो पहले एक सैंपल लिया जाता है कि उनकी सिस्टमैटिक इंपॉर्टेंस के बेसिस पे सैम्पलिंग की जाती है, और इसमें जो स्मॉलर बैंक्स हैं उनको हटा दिया जाता है. क्यों स्मॉलर बैंक्स को इंक्लूड नहीं किया जाता? बिकॉज दे आर स्टिल ग्रोइंग, एंड अगर उन पर एक्स्ट्रा कंपल्शंस लगा दिए जाएंगे दे विल नॉट एबल टू ग्रो. ठीक है, फिर एक डिटेल स्टडी होती है और एक सिस्टमैटिक इंपॉर्टेंस स्कोर कैलकुलेट किया जाता है हर एक बैंक के लिए, एंड बेस्ड ऑन दैट अगर वो एक थ्रेशोल्ड को क्रॉस करते हैं तो उन्हें D-SIBS का या डोमेस्टिकली सिस्टमैटिकली इंपॉर्टेंट बैंक में उन्हें डाला जाता है. ठीक है, सो जो RBI है उसने ऐसे 4 बकेट बना रखे हैं, एंड उसमें जो ये रेंज है ये 0.2 से लेके 0.8% तक वेरी करता है. ठीक है, तो 0.2 से लेके 0.8% तक ये वेरी करता है, एंड इस बेसिस पे 4 बकेट्स में डाला गया है. तो सबसे पहला बकेट है 0.2% का, जिसमें ICICI बैंक को डाला है. फिर 0.4, 0.6 जिसमें HDFC है, एंड 0.8% में आता है SBI. So SBI is the most important bank, and we know, we have general idea about it, right? Now what these banks have to do, what is the extra compulsion they need to follow? So they need to maintain an additional common equity tier CET1 requirement as a percentage of the risk weighted asset. Now we know that बैंक को क्या करना होता है कि वो जितने बड़े होते हैं या उनका रिस्क जितना बड़ा होता है उनको उस अकॉर्डिंग कुछ फंड जो है या जो कुछ पैसे हैं वो अलग से उठा के रखने पड़ते हैं एसेट को, सो दैट अगर कोई भी फेलियर का रिस्क आता है तो वो उन फंड को यूज़ कर सकें जिससे बैंक रन या फेलियर ना हो. तो उन्हें हम बोलते हैं रिस्क वेटेड एसेट, कि जितनी रिस्क है उसके अकॉर्डिंग हम वे करके कुछ एसेट को वी सेट असाइड. नाउ एज अ परसेंटेज ऑफ दीज रिस्क weight asset, they have to maintain the additional common equity tier, means they have to keep extra fund aside, extra asset aside to cover that additional risk of being too big. Understood? ठीक है, तो ये तो हो गया. एंड इन केस ऑफ फॉरेन बैंक इज ऑल्सो अ G-SIB. नाउ जैसे इंडिया में क्या होता है, वी हैव D-SIB दैट इज डोमेस्टिकली SIB, एंड अगर ग्लोबली कोई बैंक है तो जो ग्लोबली ऑपरेट करती है तो इट कैन बी अ G-SIB, राइट. तो उससे भी और वो इंडिया में ऑपरेट कर रही है उन्हें भी एडिशनल CET टियर मेंटेन करना होता है प्रोपोर्शनल टू देयर रिस्क वेटेड एसेट इन इंडिया. सो banks are selected for computation of systematic importance based on the analysis of their size. Basel 3 जो leverage ratio होता है, तो Basel 3 में अलग अलग नॉर्म्स होते हैं. ये बैंक को फेलियर से बचाने के लिए Basel 3 के नॉर्म्स होते हैं विच यू मस्ट हैव रेड इन द इकोनॉमिक्स. ठीक है, जैसे 2% ऑफ GDP से अगर बड़ा है तो उन्हें भी सैम्पल में इंक्लूड किया जाता है. ठीक है, तो बेसिक टेकअवे इज कि RBI ने फिर से SBI, ICICI बैंक एंड HDFC को रिटेन किया है एज D-SIB, एंड वी अंडरस्टूड व्हाट इज D-SIB. These are banks which are too big to fail, so they are calculated based on some parameters like the Basel 3 leverage ratio, and they are computed on the basis of their systematic importance. the size of the contribution, like as percentage of GDP, that is 2%, and then they are put in different bucket, and then they have to maintain the extra additional common equity there as percentage of their risk weighted asset. So this help in making the banking sector more resilient and protected from the future risk. I hope this much is clear. Now let us move on to the next topic, that is extending need of protection online. So why we need the protection online? So Supreme Court has recently in the judgment of Just Right for Children Alliance. So this is very important article from the perspective of the means. So Supreme Court has stated that mere storage of possession of pornographic material involving a child when done with a specific intent is an offence without requirement of actual transmission or dissemination, and it is the violation of the POSCO Act read with the section 67B of IT Act. Now let us deconstruct it. सुप्रीम कोर्ट ने क्या कहा है, पहले कंटेक्स्ट क्या है. वी नो वी आर लिविंग इन अ डिजिटल एज जहाँ पे कोई भी रॉन्ग मटेरियल है, जैसे चाइल्ड पोर्नोग्राफिक मटेरियल है या सेक्सुअली एक्सप्लॉयटेटिव मटेरियल है या फिर इवन फॉर द बुलिंग एंड ऑल दीज थिंग्स, इट इज़ वेरी इजी टू डन. ठीक है, बहुत जल्दी स्प्रेड होता है, बहुत जल्दी इन मटेरियल को आप कोवर्टली वायरल कर सकते हो. नाउ दीज आर वेरी हार्मफुल for the person, for the child, for their family, for the society and as a whole and for the nation as well. तो सुप्रीम कोर्ट ने इन द लेटेस्ट जजमेंट में कहा है नॉट ओनली कि अगर आप पोर्नोग्राफिक मटेरियल बना रहे हो या उसे स्प्रेड कर रहे हो वो तो क्राइम है ही, बट अगर आप उसे स्टोर भी कर रहे हो, अगर आप उस मटेरियल को कंज्यूम भी कर रहे हो, देन ऑल्सो यू आर इक्वली लायबल, यू आर ऑफ डूइंग एन ऑफेंस अंडर द पॉस्को एक्ट एंड द सेक्शन 67B ऑफ IT एक्ट. एंड नाउ इट इज़ पनिशेबल. तो एनी फॉर्म अगर आप कंज्यूम कर रहे हो, प्रोड्यूस कर रहे हो, स्प्रेड कर रहे हो चाइल्ड पोर्नोग्राफिक मटेरियल को, इट इज़ एन ऑफेंस अंडर पॉस्को एक्ट एंड सेक्शन 67B ऑफ IT एक्ट. ठीक है, तो now what section 67B क्या बोलता है IT एक्ट का? It says it criminalizes any act of transmission of the obscene material involving children, कि अगर आप ऐसा कोई भी कंटेंट को स्प्रेड कर रहे हो, एंड वी नो पॉस्को एक्ट में कि आप जो भी सेक्सुअली एक्सप्लॉयटेटिव मटेरियल है ना ही वो फॉर्म कर सकते हो ना ही आप उन्हें स्प्रेड कर सकते हो. ठीक है, इवन इन दी शरद बाबू दिगुमर्ती केस सुप्रीम कोर्ट हैज सेड दैट सेक्शन 67, 67A and 67B of IT Act make a complete code, and any visible form of sexual abuse through electronic medium is interpretation is under an offense and prohibit dissemination, creation, possession and propagation. So creation, possession and propagation and consumption as well as various ways of direct and indirect act of online sexual denigration as an offense. ठीक है, and also in Supreme Court in Avik Sarkar case has now the next thing is कि Supreme Court ने हिकलिन टेस्ट, तो ये एक टर्म आपको याद रखना चाहिए कि हिकलिन टेस्ट क्या होता है. तो एक टेस्ट होता है फॉर द ऑब्ससीनिटी एस्टैब्लिश्ड बाय एन इंग्लिश केस. तो एक लीगल टेस्ट होता है कि कोई मटेरियल ऑब्ससीन है या नहीं. तो ये क्या कंसीडर करता है, ससेप्टिबिलिटी ऑफ द पीपल हुज माइंड आर लाइकली टू गेट करप्ट व्हेन द ऑब्ससीन मटेरियल एज पर द कम्युनिटी स्टैंडर्ड इज कंज्यूम्ड. तो मतलब कि जो पर्सन है वो कैसे इम्पैक्ट हो सकता है, कैसे करप्ट हो सकता है अगर वो ऐसे मटेरियल को देखते हैं, स्प्रेड करते हैं. बट वी नीड टू इंश्योर. अब सुप्रीम कोर्ट ने इसको जो ये टेस्ट है हिकलिन टेस्ट को इसलिए से अंडरमाइन किया है बिकॉज कोर्ट ने कहा है कि जो मॉरल्स है या नेशनल स्टैंडर्ड्स है, मतलब सोसाइटी के जो भी एथिक्स है या नेशनल स्टैंडर्ड है, हमें उन्हें भी ध्यान में रखना होगा. वी कैन नॉट थिंक ओनली अबाउट अ ग्रुप जो इम्पैक्ट हो रहे हैं, बट द होल सोसाइटी इज गेटिंग करप्टेड, द होल नेशन standard gets degraded when such acts are done. So we cannot just rely on this small, we cannot narrowly interpret the graveness of the situation, right? Why? Because it violates the body integrity, the natural rights, human dignity. ठीक है, फर्दर सुप्रीम कोर्ट ने क्या कहा है, पहले क्या था कि अगर आप पे राइट टू प्राइवेसी या राइट टू व्यू इन प्राइवेट या आपके राइट्स के अंदर जो ये टाइम था कि अगर आप कंज्यूम करो उसे एक ऑफेंस नहीं माना गया था क्योंकि आप पे एक राइट टू व्यू इन प्राइवेट था. बट सुप्रीम कोर्ट हैज सेड दैट राइट टू प्राइवेसी या राइट टू व्यू इन प्राइवेट कैन नॉट बी एक्सटेंडेड टू सच हीनियस क्राइम ऑफ व्यूइंग और कंज्यूमिंग द चाइल्ड पोर्नोग्राफिक एक्ट्स. व्हाई? Because these degrade the national standard, the ethical principles of the society. They are violative of the bodily integrity, the human dignity. And so they cannot be stretched because they have a very big impact on the society. And when law act as an agent of social change, so community standard test needs to be evaluated कि हमारे whole nation का क्या एक standard होना चाहिए and law should be in aligned with that. राइट। तो इसमें भी आप GS4 से लिंक कर सकते हो, हाउ द एथिक्स ऑफ द सोसाइटी एंड हाउ द लॉज ऑफ द नेशन दे नीड टू बी इन सिंक विद ईच अदर, दे नीड टू को इवॉल्व, राइट। So reasonable restrictions become very important on these, and you can also quote right theorist Donald Dworkin, ठीक है, आप इन्हें कोट कर सकते हो, जो परसीव कर, उन्होंने कहा था कि हमारे जो राइट्स है, हमारी जो सेल्फ रिस्पेक्ट है और हमारी जो डिग्निटी है, ये तीनों इंटर रिलेटेड है, यू कैन नॉट सेपरेट देम, and to respect people as and in themselves and view them as having a basic human dignity form the essence of natural right. Now can you please tell me, आपने ये कहाँ पढ़ा है, to respect people as and in themselves? Can you think? Yes, इन पेपर GS4 आप जब इमैनुअल कांट की जो कैटेगोरिकल इम्पेरेटिव है, हम उसमें पढ़ते हैं कि पीपल, द ह्यूमन, दे शुड बी रिस्पेक्टेड एंड दे शुड बी ट्रीटेड एज एंड इन देमसेल्फ एंड नॉट अ मीन्स टू एन एंड। आप बच्चों को एक मीन्स की तरह यूज नहीं कर सकते हो टू अर्न द मनी, दे आर एंड इन देमसेल्फ, दे नीड टू बी रिस्पेक्टेड, देयर डिग्निटी शुड बी मेंटेन्ड, their rights should be protected, there should be self-respect, and their dignity should be maintained. So all these are correlated, and when you add these dimensions to your answers, then it becomes a holistic answer. So you can use that as an example also, this case as an example in GS paper 4. Right, so you cannot create, or you cannot also give an excuse that it creates the employment opportunity for the people who are involving in such act. You cannot put morality here that you are providing employment. It is immoral in every sense. It should not be done, right? So I hope now you understand how to relate the different papers, how you can link polity with the GS paper 4, right? So these holistic interconnections are very important if you want to score good in the examination. Now let us move to another article, that is the on the bulldozer verdict, and this article is very important. So this article is about the Supreme Court judgment on bulldozer verdict, where the Supreme Court has reiterated the rule of law and separation of power. So this article is very important from the perspective of GS paper 2 polity section, and especially the rule of law under Article 14 and separation of power. So these become very important because they constitute the basic structure of our constitution and also the part of the fundamental right. So we know that in some state the bulldozer justice term was very much famous or infamous because it was seen as a method of quicker justice delivery, where the suspect or the accused, their houses, they were bulldozed to deliver the justice. However, Supreme Court has said that this is unconstitutional. Now let us see why it is so. So Supreme Court has established the safeguard against the arbitrary demolitions which are taking place, and Supreme Court has said that this is the misuse of the executive authority. So before delving deep into the topic, we should know what is separation of power doctrine and what is rule of law. So what does Article 14 says? We all know that Article 14 talks about rule of law, and it talks that nobody is above the law and everyone is equal before the law, right? And nobody can be given punishment except the what is established in the law. And what separation of powers says, that all the three organs of the government, that is the executive, judiciary and the legislature, so they have to function within their own powers which are prescribed by the law, and they cannot enter or they cannot go into others' domain. So and it is also said that they have to maintain within their limits of Lakshman Rekha, right? So this was said by Vice President earlier. So in a democratic state, the rule of law and the separation of power, they are important for the equitable legal system and for maintaining the public order, right? And the importance is of lawful procedure, judicial oversight and constitutional protection. So court has emphasized it because these are the cornerstone of a democratic society where the law is supreme, right? And only the judiciary, the judge, can impose the penalties preventing the executive from acting as a judge and executioner by demolishing property. So here they are violating the separation of powers. How? Because here the executive is entering into the domain of judiciary by imposing the penalty by demolishing, but imposing penalty and looking at the judgment is only the task of judiciary. So this is again separation of power. Now court has emphasized on mainly four doctrines First is rule of law and separation of powers. Second is doctrine of public trust and public accountability. Third is right of the accused. And the fourth is right to shelter. So we will look one by one. So what rule of law and separation of powers states? That no one is above the law of the land and that everybody is equal before the law. So this forms the part of the basic structure and Article 40, and no one can be punished or made suffer in body or good except for a distinct breach of law established in the legal manner before the ordinary court of the land. So this is what about rule of law is. And when the government is demolishing the properties, so they are not following the procedure, or it is not done within any under law, or they are not even following the judicial procedure, right? So this is against their law, and they are also entering into the power of the judiciary. So all actions by the state must be governed by the legal principle, not discretionary, and they must be just, fair, and protect the human right and dignity of all. Okay, then as the rule of law is the part of the constitution basic structure, so it cannot be violated, and the executive cannot replace the judiciary in performance of its action, and that arbitrary demolitions without the judicial oversight are impermissible, right? The next doctrine is the doctrine of public trust and public accountability. So what it says that the fundamental expectation in a democratic society is that authority on the behalf of the public is bound by the trustee to act as the trustee of the citizens. Means they have the power which is given by the citizens under the social contract, and in this scenario, it is the duty of the state to responsibly use this power. They cannot use it arbitrarily or against the natural rights and the legal right of its citizens. So like in environmental cases, the government is considered as the custodian of the natural resources for the public benefit. That is like the natural resources, the air, the trees, they all are the public good, right? And these resources, the authority of governing these resources are given by the citizens to the government to maintain them for the good of all. That is why under Article 21, the right to clean environment, right to pollution-free environment is also a fundamental right. Similarly, if the power is given by the citizen to the government, it is the responsibility of this government to use this power in a fair and in a proportionate and a reasonable manner for the good of the all the society and the citizen. So it is the doctrine of the public trust, that it is the trust of the public that the government has to withhold, and also the accountability. Government should be accountable for its action to the citizens, right? So all the state power exercised by the public servant or officials must be in accordance with the public trust. And in Delhi air tax service case also, they have pointed out that public officials must faithfully discharge their duties in a manner that promotes the public good and avoids the arbitrary and harmful actions. And also, if the state actions causing harm, they are accountable under the public law. So like here what the Supreme Court has said, that demolishing without the judicial procedure is like they are harming the citizens, they are devoiding the accused of their rights, and that is why they are accountable under the public law. So such like the court warned that effectively turn the executive into the judge and jury, and usurping the judicial authority, which is against the separation of the power. To prevent such executive arbitrariness, the bench has called for the binding directives which are aimed at increasing the transparency and fairness. So court has said that there should be certain directives in which there should be transparency, so that such actions cannot be taken and there should be accountability. The next doctrine is the right of the accused, which means कि कोई accused और convict में क्या अंतर होता है? Accused मतलब जब आपने accusation किया है कि इस person ने शायद crime किया हो, but it is not get proved in the court of law, and जब प्रूफ हो जाता है कि person is guilty of the crime, then they are convicted, right? तो अगर कोई person एक accused भी है, तो भी they enjoy certain right. Even the convicts, they enjoy certain fundamental right under the constitution, which is intrinsic to their dignity. Again, कोई भी इनह्यूमन या आर्बिट्री ट्रीटमेंट आप नहीं कर सकते हो, एंड जो भी पनिशमेंट या पेनल्टी है वो एक ड्यू प्रोसेस के बिना आप इम्पोज नहीं कर सकते हो. अगर एक्स्ट्रा जुडिशनल डिमोलिशन हो रहा है प्रॉपर्टी का, तो ये होली अनकॉन्स्टिट्यूशनल हो जाते हैं इसी के अंडर, ठीक है. जैसे सुनील बत्रा केस में कोर्ट ने कहा था कि प्रोटेक्शन ऑफ द प्रिजनर राइट अगेंस्ट द स्टेट एक्सेस including the prohibition of inhuman practices like the iron fetters or solitary confinement. तो ये आप नहीं कर सकते हो. ऐसी चाल सॉब्रेज केस में भी बोला था कि प्रिजनर्स दे मेंटेन द राइट एज सिटीजन्स. तो प्रिजनर्स होते हैं वो सिटीजन के जो राइट्स हैं वो एंजॉय करते हैं, एंड लिमिटेड ओनली टू द नेसेसिटीज ऑफ कन्फाइनमेंट. अगर उन्हें कन्फाइन अंडर द लॉ के अंदर किया जा रहा है आफ्टर प्रॉपर प्रोसीजर, तो फिर आप उन्हें कन्फाइन कर सकते हो, आप उन्हें इम्प्रिजन कर सकते हो, बट स्टिल दे डोंट लूज द राइट ऑफ सिटीजन्स. Okay, so this is Charles Saurabh जी case and Sunil Batra case. So can you tell me ये किस आर्टिकल के अंदर आते हैं? Is it Article 20 or is it Article 22? think about it, then central to court analysis is the presumption of innocence. Now you must have heard that innocent until proven guilty, मतलब आप एक्यूज हो बट अभी आप प्रूवन गिल्टी नहीं हो, अभी आप कोर्ट ऑफ लॉ में स्टैब्लिश नहीं किया गया है कि एक क्राइम आपने ही किया है, तब तक आपको एक इनोसेंट की ही तरह ट्रीट किया जाता है. सो दिस प्रिजम्पशन ऑफ इनोसेंस कि आप इनोसेंट हो जब तक ये प्रूफ नहीं हो जाता है कि आपने एक क्राइम किया है. एंड दिस इज द बेडरॉक ऑफ द क्रिमिनल जस्टिस सिस्टम, stressing that no state authority can unilaterally judge or punish an individual based on mere allegation. तो आप सिर्फ एलिगेशन पे तो जज नहीं कर सकते हो ना, वरना फिर क्रिमिनल जस्टिस सिस्टम अच्छे से रन ही नहीं करेगा. They cannot circumvent the judicial process and the principle of fairness and making this impossible. तो आपको प्रिंसिपल ऑफ फेयरनेस और जुडिशरी प्रोसेस को तो फॉलो करना पड़ेगा ना. अगर आपको लग रहा है किसी ने क्राइम करा है पर आप उनके घरों को ऐसे डिमोलिश नहीं कर सकते हो जब तक वो क्राइम प्रूफ नहीं हो जाता है. ठीक है, सो यू नीड टू फॉलो द रूल ऑफ लॉ, द इंडिविजुअल लिबर्टीज एंड द नेचुरल जस्टिस प्रिंसिपल. सो क्योंकि अगर ऐसा आप कर रहे हो कि कोई भी एक पर्सन है या स्टेट अथॉरिटी को यूज़ करके आपके घरों को डिमोलिश करिए विदाउट फॉलोइंग द ड्यू प्रोसेस ऑफ लॉ, तो इट इज़ लाइक माइट इज राइट, क्योंकि यहाँ गवर्नमेंट पावरफुल है तो उन्हें जो करना है वो कर रहे हैं. और मान लो अगर आपको बाकी प्रूफ होते कि आपने वो क्राइम किया ही नहीं बट आपका तो घर डिमोलिश हो गया ना, तो यहाँ पे तो एक इनोसेंट को भी सजा मिल रही है. So you have to follow, क्योंकि एक इनोसेंट को आप सजा नहीं दे सकते हो. द नेक्स्ट प्रिंसिपल इज अबाउट द राइट टू शेल्टर, एंड राइट टू शेल्टर इज अंडर आर्टिकल 21. ये एक हमारा फंडामेंटल राइट होता है बिकॉज ये एक सेंस ऑफ डिग्निटी देता है, सेंस ऑफ बिलोंगिंग रहता है. हर किसी को हक है कि उनका एक खुद का अगर घर है तो उनके राइट टू शेल्टर होना चाहिए. एंड ऑल्सो एक टेस्ट ऑफ प्रोपोर्शनैलिटी. वाई? क्योंकि जब आप एक घर को डिमोलिश कर रहे हो तो उसमें जो उनके फैमिली मेम्बर्स हैं जो इनोसेंट है, उनका कोई हाथ नहीं है, उनकी वाइफ है, हस्बैंड है, स्पाउसेस हैं, तो वो भी तो सफ़र कर रहे हैं ना, आपने उनका भी राइट टू शेल्टर छीन लिया है. तो दिस डज नॉट स्टैंड दी डॉक्ट्रिन ऑफ प्रोपोर्शनैलिटी और प्रिंसिपल ऑफ फेयरनेस एंड अकाउंटेबिलिटी. तो चमेली सिंह केस में ये बोला था कि इट इज़ अ फंडामेंटल राइट टू शेल्टर. ठीक है, एंड द इम्पॉर्टेंस ऑफ प्रोफेशनैलिटी, तो ये मॉडर्न डेंटल कॉलेज केस में और पुट्टू स्वामी केस में, विवेक नारायण केस में 2023 में बोला था दैट जो आपको प्रिंसिपल ऑफ प्रोफेशनैलिटी फॉलो करना चाहिए. इट मीन्स कि पहले आपको देखना चाहिए कि आप जो क्राइम है या जो भी एक्यूज्ड है उसका कितनी ग्रेवनेस है उस क्राइम की, उसके अकॉर्डिंग आपको पनिशमेंट देना चाहिए. तो आप पहले लेस इंट्रूसिव ऑप्शन अपना सकते हो, पार्शियल डिमोलिशन कर लो या कंपाउंडिंग कर लो. अगर कंप्लीट डिमोलिशन इज द ओनली लीगल ऑप्शन अवेलेबल तभी आप ऐसा करोगे. ठीक है, तो ये है इंपॉर्टेंस ऑफ प्रोफेशनैलिटी, मतलब जितना आपकी ग्रेवनेस ऑफ क्राइम है उतना ही आपको पनिशमेंट देना चाहिए. और एक होता है डॉक्ट्रिन ऑफ कलेक्टिव पनिशमेंट. सो दे हैव डिनाउंस दिस कि आप एक की सजा पूरी फैमिली को नहीं दे सकते हो. इंडिविजुअल रिस्पॉन्सिबिलिटी होती है, कलेक्टिव आप पनिशमेंट नहीं दे सकते हो. तो यहाँ पे उनकी फैमिली को भी सफ़र करना पड़े, विच इज़ रॉन्ग. ठीक है, so individual guilt or innocence must be determined separately, and the presumption of innocence until proven guilty means that no individual or family should suffer. So commitment to constitutional values of principle of fairness के भी अगेंस्ट है ना, उन्हें कुछ क्राइम नहीं किया फिर भी उनको पनिशमेंट मिल रही है, तो दिस इज नॉट फेयर एंड इन अ डेमोक्रेटिक सोसाइटी दिस शुड नॉट हैपन. सो बेस्ड ऑन दिस राइट टू शेल्टर, बेस्ड ऑन द प्रिंसिपल ऑफ प्रोपोर्शनैलिटी, बेस्ड ऑन द डॉक्ट्रिन ऑफ collective punishment should not be given, the rights of the accused, based on the doctrine of public trust and public accountability, rule of law and separation of power, court has held that this is unconstitutional and this bulldozer justice should not be there. They should follow the due process of law. So I hope you gained some insight into this topic, and this video was informative and useful to you. Thank you. If you like, please share and subscribe. Thank you.